Hi, I'm Susan M. of ImLaw. I have been practicing exclusively immigration law for over 15 years. Today's topic is the K-1 Fiancee Visa. What are the requirements of this visa category? Well, in order for one to petition for a foreign national fiancé, the petitioner must be a U.S. citizen. Permanent residency is not enough. You must be a U.S. citizen. And the U.S. citizen must have met the foreign fiancé in person within 2 years of the date of filing the K-1 petition. There are some exceptions for waivers, but in general, you must prove that you met your fiancé within 2 years in person. It's fine that you met on internet, it's fine you're keeping in touch on internet, but if internet is all you have, it's not going to be enough for immigration. Third, the couple must have a bona fide, true intention to marry. You must have a true intention to marry that fiancé. And fourth, the U.S. citizen petitioner must be legally able and willing to consummate a valid marriage with the fiancé, and vice versa. The fiancé must be legally able and willing to marry that U.S. citizen petitioner within 90 days of the fiancé's arrival. And actually, you do have to prove that you're legally able to enter into a marriage at the time of filing the K-1 petition. What sort of documentary evidence does one have to include in a K-1 petition? Well, the first agency that you're dealing with in a K-1 case is the U.S. Citizenship and Immigration Service, otherwise known as the USCIS. And with that K-1 I-129 petition, you must include evidence that the parties have met within 2 years. This might include photos, it might include other evidence such as boarding passes and flight itineraries, receipts of things that you did together in the foreign country. You also want to include evidence of the parties' legal ability to enter into a marriage with the foreign fiancé, and this would include divorce certificates, proof of termination of the prior marriages, if any, as well as annulments, death certificates, if that's what applies in the particular case. And you want to include the evidence of the parties' legal ability to marry on both the U.S. citizens' side as well as the foreign national side. You also want to include evidence of how the couple has maintained their relationship, that this is a genuine relationship. And this could include photos, phone bills. Very important to talk about phone bills, because USCIS and the U.S. Embassy, where the foreign national will eventually go for the K-1 visa interview, does not recognize phone cards. And phone cards and Skype, it's very often difficult to document that relationship and the communication. You do want to have some phone bills that show some concrete calls going back and forth between the parties. Emails, if you have text that you're able to print out, very, very helpful to include. Letters with original envelopes and the stamps on them, receipts for engagement ring, receipts for anything else, such as Western Union, if the U.S. citizen is sending money to the foreign national, is often the case. Maybe you've got flight itineraries for the trips that the U.S. citizen has taken to visit that foreign national abroad. Maybe you have affidavits of persons such as family members or friends that have knowledge of the couple's engagement and relationship. So again, the first agency we deal with on a K-1 case is the USCIS. That's where we file the K-1 petition package. And upon approval of this K-1 petition, the USCIS will send this case to what's known as the National Visa Center, which in turn will conduct some preliminary processing but turn the case over to the U.S. Embassy or consulate in the foreign national's country, typically, or whichever U.S. consulate that is designated in the K-1 petition. An approved K-1 petition, and approval is valid for 4 months. A U.S. consular or embassy officer does have the authority to revalidate that petition for additional 4-month periods where necessary. There is an automatic termination of an approved petition where the U.S. citizen petitioner unfortunately dies or withdraws the petition. Maybe the relationship has gone south sometime in the process before the foreign national arrives in the United States. Some quirks about the K-1. If the parties fail to marry within 90 days of the K-1's arrival to the United States, so remember, we have the petition process, we have approval, the case goes to the National Visa Center. National Visa Center will then send the case to the U.S. Embassy. The U.S. Embassy will schedule the interview, and the foreign national will attend that interview. If everything goes well, the foreign national will obtain a K-1 visa and use that visa to come to the United States and obtain entry. If the parties fail to marry within 90 days of the K-1's arrival, the K-1 is required to leave the United States, and failure to depart renders that person removable from the United States. A common question and this has come up many times in my practice. What if the marriage to the foreign national doesn't work out, and the foreign national then magically meets another U.S. citizen and wants to marry him or her? That doesn't work in immigration law. That does not solve that K-1's problems. The K-1 foreign national must marry the U.S. citizen petitioner that is listed on the I-129F petition. A K-1, again, can only adjust status to permanent residence, meaning file for the green card after that marriage within 90 days, based on marriage to the same U.S. citizen petitioner on the K-1 petition. Additional quirks. If the K-1 has a dependent child under the age of 21, that child can be eligible for a K-2 dependent visa as long as that child is listed on the K-1 petition that was filed with USCIS. Now, sometimes a K-2 child may be stuck completing school abroad, and they're mid-year in school, and they're not able to come to the United States at the same time as their K-1 mother or father. Well, the good news is the Foreign Affairs Manual does allow for a one-year cutoff date, meaning that the K-2 does have 1 year within which to arrive in the United States. So that gives a little bit of time, especially for those dependents who are students. K-2 dependents are not covered by the Child Status Protection Act if they turn the age 21 before they are approved for green card status. So not even before they're approved for the K-2 dependent visa, but before they come on the K-2 visa to the United States and then file for the adjustment of status known as the green card process and get approved. They must get approved for green card status in the United States before they turn age 21. No exceptions, and that's an unfortunate hole in the immigration laws. The K-2s are not covered by that Child Status Protection Act. So it's very important that if we have an age-out issue, a child that's going to be turning 21, sometime in that K-1 process or K-2 process, this is an issue that needs to be flagged by the attorney that you're working with on the petition itself, and that each agency that's involved in the K process should be reminded of that age-out issue all along. K-1s and K-2s cannot extend their K status once they have entered the United States with that K visa, and they can't apply to change their status to another visa category. Again, stemming back to if they fail to marry, the K-1 fails to marry the same U.S. citizen petitioner, they need to leave and they need to go home. They can't try to stay in the United States by extending their stay or changing to another visa category. It is specifically prohibited by the laws. Well, that's it today for K-1 fiancé visas. I'm Susan Im of ImLaw. For more information, please visit imlaw.biz.